All right, first case, which is Gondolier Properties versus Tilseth, et cetera, and so forth.
Yes, Your Honor.
We have, I see Mr. Crockett, I see Mr. Coleman. Are we going to see Mr. McKee?
That's the second case, Your Honor.
Okay, well, I know he's on the second case and he's mentioned on the first, on my docket on the first case, but he will not be appearing in this first case.
Correct, Your Honor.
Okay, have you discussed how you want to proceed? I mean, we're going to argue these one, and we're obviously not going to do it one together if Mr. McKee's not here. So have you discussed how you're going to proceed time-wise?
Unless the court has another direction, we were going to just have the first case argued, which is the Don Tilseth case for 20 minutes. And then the second case, which is the Jody Tilseth appeal, argued for another 20 minutes.
Okay, and the first case, is that it's got a cross appeal?
Yes.
It does, Your Honor.
Okay, so keep in mind that you in the cross appeal are going to be entitled to rebuttal if you want. So think about whether you want to reserve some time for that too. Okay, so let's have at it.
Thank you, Your Honor. Jeff Crockett for Gondolier Properties. I would like to reserve 10 minutes for rebuttal and to deal with the cross appeal.
Okay.
There are two primary points on this appeal. One, whether Don Tilseth is liable for treble damages, and second, whether the trial court correctly held a trial rather than confirm the arbitration award. And I'll deal with both of those in the first section of the argument. Unless the court has another direction, I'll deal with the treble damages point first. In this case, Don Tilseth was sued for conspiracy to commit civil theft, along with his wife and three entities that they controlled. That's count 12 of the pending complaint. It was proven that Don Tilseth was liable for conspiracy to commit civil theft. And that's not in question. There's no debate on sufficiency of the evidence. There's no challenge to the jury instructions. There's no challenge to the fairness of the trial. So it's proven that Don, together with his wife, agreed to loot Gondolier and use it as their personal piggy bank while hiding their actions through two sets of books, false tax returns, multiple invoices, fabricated contracts, and destroying evidence. It's $500,000 of the $1.2 million stolen by our employee, Jody Tilseth, went directly to Don's benefit. So the issue here is the trial court denied treble damages, which we asked for on the verdict for conspiracy to commit civil theft. We say just as a getaway driver in a bank robbery who never touched the gun is liable for the murder committed by his accomplice inside because he agreed to share the proceeds. Just like a cigarette company and Boatwright that never sold the dead plaintiff with lung cancer a cigarette is liable under conspiracy. In this case, Mr.
Well, let me ask you a question there, based on your analogy. And I know the analogy is sort of the tail wagging the dog, but let me back into this way because I may not remember the pleadings correctly. But do I understand that Don Tilseth was named in the conspiracy count, but not in the underlying civil theft count, correct?
Yes, that's correct, Your Honor.
Okay, well, in criminal, which we're not here in criminal law, I get it. But if you're named it, if count one, X crime, count two, Y crime, the person in count two is an aider and abetter of count one, but it's not named in count one as an aider and abetter, they don't get convicted. True. Of that charge. And they don't get a sentence for that charge. So why should he get a treble damage on a conspiracy versus a treble damage on the underlying the crime that the conspiracy was aimed at? If he wasn't named in the count.
The court has put its finger exactly on the issue, which is
I love it when I do that.
If someone is charged with conspiracy to commit theft and found liable for that. That's the question. Are they liable for treble damages, although they're
Weren't charged in the underlying tort.
count?
They
Can I
weren't.
ask you a question about that? You're saying they're charged that he was in account for conspiracy and the underlying wrongdoing was civil theft. The opposing counsel might take issue with that. What is the underlying tort on which the conspiracy count was based?
There is a statement in Mr. Tilset's brief that he was not charged with conspiracy to commit civil theft. But if one looks at count 12, that is completely wrong. He was clearly charged with conspiracy to embezzle with his wife, that was the
civil theft mentioned in the conspiracy count?
Yes, absolutely.
The word civil theft referenced in the conspiracy count against Don?
Definitely theft is I have the definitely and moreover that he agreed to it, that they were jointly and severally liable, that they did it together, that it was for his benefit. Well, let me leave that aside.
We can leave that aside. Let's assume. Go ahead.
But anyway, we certainly think we do not win if he was not charged with conspiracy to commit civil theft. We agree that it had to be pled, and it clearly was. And by the way,
the safe harbor letter had to be addressed to that person.
And the safe harbor letter, which is R1038, it's in our appendix at 71, was addressed to the counsel for both Mr. and Mrs. Tilseth. It stated that Mrs. Tilseth did the theft for the benefit of her husband, and that's alleged right in there. So there was an opportunity to settle. There was knowledge of the allegation, and there was allegation of joint and several liability for the Mrs. Tilseth.
Well, if the safe harbor letter, what did the safe harbor letter say? Did it say Jody and Don, or did it just say her? Because if it only says her, how does Don have an opportunity for safe harbor?
Well, the letter states, the theory of the case, by the way, is that the actual theft, the person who had her hand in the cookie jar was Jody Tilseth.
Right.
Conspiracy with the others. And right. The demand letter says if Jody Tilseth doesn't pay, there will be a claim for civil theft filed. And ultimately that was filed against Jody, with a conspiracy against him seeking joint and several liability. So I think it ties in at this point to, there are two cases I want to talk about. One is this court's case, Bell versus Snyder, which says the treble damages are remedial. So they're not punitive, as Mr. Tilseth argues. They're remedial, meaning they're to be interpreted broadly. They're for the purposes of giving compensation to victims, deterring the conduct. And that is in the same way that one cigarette company which didn't sell one cigarette to the plaintiff is liable. This gentleman who did not steal the money, he did not steal the money directly, but he conspired and he received it, and he helped to hide the books and do the tax returns and all the rest of it, is liable for treble damages. So that's coming from the theory of remedial. The closest case on this point is from the third district case of 6F Corporation versus BDP. And this involved a gentleman named Castillo, who was sued for civil theft, got a civil theft demand, but the money was taken for the benefit of not only of his 4 corporations. The trial court said 4 corporations which got the benefit and which the complaint alleged were jointly and severally liable with him. All 5 were held liable for treble damages under civil theft. So and the dissent in that case by Judge Cope very clearly makes this exact same argument Mr. Tilseth makes. There's no demand letter addressed to the 4 corporations. They were not sued in civil theft count. And the majority said they're sued. There was a request for joint and several liability, which is proper under the law. Therefore, they get treble damages for civil theft. So those essentially are the two cases we relied on. But again, it flows from the conspiracy, where the conspiracy is where Don Tilseth got notice. He got notice that he would be fully liable for the conspiracy, including the treble damages. And that's the one case on point is a 6F case, says you don't have to give notice on the to the specific defendants if you allege joint and several liability. So unless there are other questions, I want
to compound the analogy to the criminal world. Wouldn't it be a problem if, let's say, in another universe, you could be convicted of a crime for something less than the standard of beyond a reasonable doubt, and you weren't named an account against you that required that standard, but you were named an account against you that only required a preponderance of evidence? Don't you have that problem here? Because the standard for civil theft is higher than the evidentiary standard for the conspiracy count.
Well, there's two answers to that, and I don't know which is the better one. One is that they had never asked for a convincing jury instruction. The second is conspiracy law tends to requires that you are liable for the consequence of the actions, the wrongdoings of any co-conspirators. So that law gives notice. So that's our primary contention. And if you are liable for conspiracy,
wouldn't that argument rely on the supposition that the underlying tort in the conspiracy claim is civil theft?
Absolutely. Conspiracy to commit civil theft. Yes. And that was I mean, it was also conversion, which were on the facts of this were the same, but definitely the allegation. In my next argument, I'll have found the quotations, and I'll read the court on that issue, what the allegations were. Okay, so second, I'd like to address the arbitration point, move to that. In this case, the trial court got the issue right, anticipating this court's opinion in D'Acosta. In this,
D'Acosta is in the Supreme Court right now.
Correct. There was a
on jurisdiction
on conflict. It's on. I read the briefs. The allegation is there's a conflict with other cases.
The Supreme Court has not accepted or rejected it yet.
Absolutely true. That's just pending. This court denied rehearing in bank.
Right.
The brief Don Tilseth addresses this in his reply brief, and his only answer is D'Acosta is incorrect, which of course we don't believe that that's an answer to a decision 1 year.
Atkinson, Mike.
Notwithstanding Judge Atkinson, when I was a law clerk, my judge said he had to go with the majority in the next case where the same issue. I don't know if Judge Atkinson agrees with that. But
Mr. Crockett, you're at 10 minutes now, so you.
Okay, so let me leave it there and just rely on the D'Acosta case, and I'll reserve the rest of the time for rebuttal.
Okay, that's good. All right, Mr. Coleman, you're up, and you need to unmute.
My name is John Coleman. I practice law in Fort Myers with my son, Thomas Coleman. In this cross appeal, we represent the Don Tilseth defendants. Don Tilseth, D.L. Tilseth as trustee, J.E. Wingfield as trustee, and Premier Management, Inc. Don Tilseth is the husband of Joellen Tilseth. Joellen Tilseth is represented on appeal by Jim McKee. In my oral argument, I will address the same two issues that Mr. Counsel for Gondolier addressed. First, Gondolier Properties.
Let me ask you, Mr. Coleman, do you wish to reserve rebuttal time on cross appeal?
Yes, I request to reserve 2 minutes.
2 minutes. Okay, good. All right. Go ahead.
First, Gondolier Properties claim that it is entitled to treble damages from Don Tilseth defendants is without merit. This argument is in response to the Gondolier appeal. Second, the arbitration award should have been confirmed by the trial court because Gondolier Properties failed to timely and properly move for trial de novo in violation of the applicable statute, the applicable rule of civil procedure, and the court orders that have been rendered in the trial court. The Don Tilseth defendants will rely on arguments presented in their briefs with regard to conspiracy and damages arguments. Treble damages may be recovered pursuant to Florida Statute Chapter 772 for civil theft. The statute specifically requires that notice be provided to a party prior to the initiation of suit. The demand must be written. You judges are fully aware of that requirement. You quizzed counsel for Gondolier about it. Gondolier was aware of the requirement. It provided statutory notice to one defendant. Joellen Tilseth is the only defendant to whom the notice was sent. The statutory notice is the only exhibit attached to Gondolier's fifth amended complaint. It is undisputed that none of the Don Tilseth defendants are named, mentioned, or referenced in the statutory notice. Not only did Gondolier fail to send the statutory notice required by Chapter 772, Gondolier failed to name any of the Don Tilseth defendants in the civil theft count of its fifth amended complaint. The Don Tilseth defendants were not named in the count, nor in the wherefore clause where Gondolier demanded treble damages from Joellen Tilseth only. This court has held time and again, it is clear error to enter judgment against a party who has not been named as a defendant under a pertinent count. In order to recover treble damages, you send the notice and you name the party in the count. There should be no question, no doubt in a party's mind as to whether they have been sued for civil theft. Anything less is not due process, notice, and an opportunity to be heard. In their briefs, Gondolier's appellate counsel adamantly assert they're entitled to treble damages for civil theft against Don Tilseth. You heard Gondolier's counsel mention that Don Tilseth was aware that he had been sued for civil theft, or should have been aware that he was sued for civil theft. However, counsel for Gondolier in the trial court admitted they did not sue Don Tilseth for civil theft.
Is there any permissible reading of the conspiracy count?
No.
To suggest that it was the underlying, or one of the underlying torts was civil theft?
No. Civil theft, the words are not found anywhere in count 5 of the fifth amended complaint. Nowhere. They claimed a conspiracy to defraud in paragraphs 101 and in paragraph 102, not conspiracy to commit theft, much less conspiracy to commit civil theft. They did not allege anything in count 5 that would put Don Tilseth on notice that he was being accused or charged or sued for civil theft. In their brief, Gondolier's counsel failed to discuss the fact that their counsel in the trial court admitted they did not sue Don Tilseth for civil theft. That is a devastating failure. It's a fatal flaw. You can't say in one place, we're not suing you for civil theft, and then appeal claim, oh yeah, we are suing you for civil theft, and you should have known it. If you don't sue someone for civil theft, there is no way that you are entitled to judgment for civil theft or treble damages. Gondolier's claim that liability for conspiracy is liability for civil theft is not true. The allegations in the conspiracy count totally failed to allege conspiracy to commit theft, much less conspiracy to commit civil theft. Gondolier specifically, as previously mentioned, alleged a conspiracy to defraud. Gondolier touts joint and several liability. Joint and several liability was mentioned twice in the civil conspiracy count, never once in the count alleging civil theft. After alleging joint and several liability in the complaint, in the count for conspiracy, we never, ever heard about joint and several liability again until months after the verdict had been rendered. Joint and several liability was not referenced during presentation of Gondolier's case, during presentation of Don Tilseth's defense, at argument on directed verdict, in closing argument, in instructions to the jury or the verdict. During argument on directed verdict at trial, Gondolier's counsel tried to raise an agency or vicarious liability argument. The trial court shut him down immediately. The trial court stated there is no basis set in count 5, the civil theft count, on which Don Tilseth, individually or as trustee, can be found responsible for civil theft. The judge aptly stated, I can't direct a verdict because Don Tilseth is not a defendant in count 5. Gondolier's claim that 6F Corporation supports their argument. 6F Corporation is an aberration. In the 10 years it has been on the books, it has never been cited once in an appellate decision. Further, 6F Corporation is clearly distinguishable. In 6F Corporation, there was no conspiracy. There was a count for civil theft. In 6F Corporation, the defendant and his sham corporations were alleged to have engaged in civil theft. No such allegation exists in this case.
Well, it didn't say that they engaged in civil theft. I think it said that the non-fictional person engaged in civil theft and the benefits flowed to the fictional people, his alter egos.
I will defer to the court's recollection on that point. In 6F, the civil theft count claims that defendants and his corporations were jointly and severally liable. So no such allegations in the civil theft count in this case. 6F Corporation was a non-jury trial. In this case, the fact finder was the jury. In this case, there were no jury instructions on joint and several liability. There was to the jury on joint and several liability. The verdict did not reference joint and several liability. There is no argument to the jury regarding anyone other than Joellen Tilseth being responsible for civil theft. There were no findings by clear and convincing evidence, as Judge Atkinson brought up, that anyone other than Joellen Tilseth was responsible for civil theft. And the jury verdict found liability for civil theft by clear and convincing evidence as to Joellen Tilseth only. Additional points mandate affirmance of the trial court's refusal to enter judgment against the Don Tilseth defendants for civil theft. We have discussed the heightened burden of clear and convincing evidence. Don Tilseth asked for a jury trial on all matters triable as a matter of right by jury. This court should also take into account that Florida Statute 772.11 is a statutory remedy. It allows treble damages. Therefore, as a punitive statute, it must be strictly construed against Gondolier. Further, 772.11 allows for an award of attorney's fees. Claim for attorney's fees must be specifically pled. No claim for attorney's fees is alleged against Don Tilseth or his related defendants in the 5th amended complaint. Again, Gondolier totally ignored this point. Finally, Gondolier should not, under any circumstances, be allowed a second bite at the apple. Gondolier had its chance. Actually, 5 chances because it filed at least 5 amended complaints. Allowing Gondolier to pursue a claim for civil theft after appeal would render a mockery of the concept of finality. In claiming the right to treble damages, Gondolier wants you to ignore the law. You cannot do that. The trial court's ruling that treble damages are not awardable must be affirmed. The second point I wish to address involves the non-binding arbitration award, which the court failed to confirm. Again, Gondolier wants you to ignore the law. They want you to ignore 44-103 sub 5. They want you to ignore rule 1.820 sub H. They want you to ignore the trial courts rendered in the lower court. The statute, the rule, and the court orders state an arbitration decision shall be final if a request for trial de novo is not filed within the specified time. All courts are required to follow the law. The plain language of the statute or the rule is to be given effect.
Let's talk about the plain language of the statute as opposed to the rule. It does use the word file, but it also uses the word it doesn't use the word motion, and it also uses the word request, or if no request is made.
Yes, but I would suggest that the filing of the motion is preeminent because that is referenced throughout the statute. There is a about served. You have to
you know, the rules of civil procedures say that you can make a motion orally in a hearing.
He did not make a motion orally.
Apparently the judge recalled that he said, yes, I want a trial de novo or a trial. Actually, you know, it's interesting. The rule and statute, none of them say de novo, but that's what it is.
The court orders said de novo, Judge.
Well, of course,
orders.
Everybody, all the case law says trial de novo, but it's nowhere. De novo is never mentioned anywhere. But in fact, that's what it is. But the court recalled that that Mr. Crockett side said, yeah, you know, we want a trial. We're going to want a trial.
No, Judge, I believe what he said was, I asked my co-counsel to put it in there. Co-counsel didn't put it in there when they filed their notice of rejection, and didn't put it in there in the week that followed the admonishment.
I think wasn't that a different?
So you say on your side that you had no idea they wanted a trial.
No, Judge.
Even though they filed a notice that they were rejecting the arbitration award.
But they did not ask for a trial.
So what would have happened then? They rejected the arbitration award. What would have happened this? And this is different than the cases that say exceptions to an arbitration award, because you can get exceptions, you know, under the old way of doing things corrected. But this was a rejection of the arbitration. What would have happened then if they're not then gone to trial?
That's not stated on the record, Judge. There is no reference to what
under the law. What would have happened?
It
wasn't if you didn't ultimately proceed to trial.
Frankly, Judge, I'm not clear.
I think it's totally.
The statute tells you, and the judge told them that they had to file a motion.
Well, you know, here's the thing too, and let me ask you this: the statute, I will concede, you know, gives a substantive right to a judgment if there's no
motion for trial.
If there's no indication of you know, we reject this arbitration and we invoke our right to a trial. I understand that, but it's not for the legislature to say how that's done. That would be a procedural issue by the court, and the legislature recognizes that by rules adopted by the Supreme Court. And the rules adopted by the Supreme Court say you can make a motion orally.
I don't believe it says that in rule.
Oh yeah, it does. It says that. No, it says that in the motions rule applicable throughout the rules of civil procedure.
Well, we're controlled also by the court orders, and the court orders in this case differentiate this matter from all other cases that we're aware of, including De Costa. The court orders in this case specifically said that there was to be a motion for trial filed. The judge himself specifically instructed counsel that they had not filed a motion for trial.
But if they said, Judge, we want a trial, they said that in the hearing.
Judge, there's no transcript of that hearing.
We are not, excuse me, Mr. Coleman, We are not bound by what the trial court told counsel.
There is,
We can look at that and say, that satisfies Rule 1.100B. It says an application to the court must be by motion, which must be made in writing unless made during a hearing or trial. Why
Judge,
doesn't that rule apply in this case?
because we're talking about issue that is addressed not only by rule, but also by statute and also by specific court orders that control the manner in which the parties are to resolve the case.
They don't control how this court resolves the case. So there's a hierarchy here.
Sure, I
We're here
understand the
to-
hierarchy. I understand the hierarchy, Judge, but the court orders differentiate this matter from all the other cases. The fact that the counsel for Gondolier were specifically put on notice that their notice of rejection was not satisfactory and was not a motion for trial differentiates this case from all others.
Well, if you're gonna rely on that they were put on notice that it was not satisfactory, then why do we have to discount the judge's recollection that prior to the final deadline for requesting a trial, the request was made in open court?
Judge, we would dispute the court's recollection if that's what it was.
But you don't have a transcript. So
That's correct, nor does the trial court have a transcript to back up what it's saying.
he doesn't need one if he remembers it that way.
Judge, all due respect, the rules control, his rules as well control. Mr. France
Well,
was,
can I pause there for a second? That's an important point, because we're arguing the text of the statute, the text of the rule, allowing for motions to be made orally, and we haven't hammered out whether we agree on the facts. The trial court recollected that in open court, prior to the deadline for requesting a trial, that it was requested in open court. And
But
so,
only-
so you're saying that didn't happen? We all agree there's no record. There was a factual finding by the trial court. So what are we to do as an appellate court?
Judge, Mr. France was co-counsel. Mr. France had another attorney and involved in the case with him. His co-counsel, Mr. Collins. Mr. Collins never requested a trial. We don't know whether Mr. France was speaking on his own, if he actually requested, or whether he was speaking on behalf of Mr. Collins as well. Actually, he said that he told Mr. Collins to put it in there and Mr. Collins didn't.
That was something that was we have a record of. There was a separate conversation that's not on the record.
But regardless, if they intended to put it in writing and didn't, what difference does it make if they made an oral request?
Who knows
That
whether,
oral request, was fully consistent with the writing that they did file, which was, we reject this arbitration result.
they did not confirm it with a statement or a document or anything else from Mr. Collins.
So you guys were just like so taken aback when this case got set for trial.
Pardon?
You guys were taken aback then when this case went to trial.
We were taken aback when our motion to confirm was not yes.
Okay, you're down to your 2 minutes, so you.
Okay, let me finish up here real quick. De Costa, we believe, is not good law. We believe that this court spoke to the issue in Bacon Family Partners, which was recognized and approved in the decision of Patterson versus Allstate Insurance. Both of those decisions preceded De Costa. De Costa court said they didn't technically follow the rule. Well, then they didn't follow the rule and they shouldn't have a.
Well, they didn't do anything in the Costa.
Yeah, they didn't. And so I'm not quite sure how the De Costa court came to the conclusion that they substantially complied. Further, there was an issue in that case about supposed gotcha tactics, a waiver. there's no such thing here. We couldn't have said it better than Judge at the trial court when he told counsel for Gondolier that their notice of rejection was not a motion for trial. Anything else? The court said it
Should it
all
matter
right.
that the word motion is not mentioned in the statute except for a motion for fees?
Judge, the court used,
Costs, pardon me.
the trial court used motion for trial. The orders of the court referenced motion for trial. There's motion for trial referenced in the title of either the statute or the rule. I apologize right this moment. I can't.
It's the rule.
Now, okay, so file a motion for trial. We didn't do anything to stop them. We didn't say anything to stop them. We didn't prevent them in any way. We didn't give them any reason not to. Finally, in DeCosta, they claimed that counsel for the hospital raised no prejudice. We raised prejudice. We have
What's the prejudice?
reasons why there was prejudice.
So you were surprised, and so you didn't do something to prepare for trial?
We
I mean, what
prepared
was
for
the
trial.
prejudice?
We prepared for trial following
What was the prejudice other than you went to trial?
the prejudice was that our motion to confirm was not granted,
I get it.
resulting in the necessity to proceed to trial.
Okay, Mr.
All the cost, all the time,
Coleman,
all the
you
attorneys.
used all your 20 minutes at this point. So,
Thank you on behalf of the Don Tilsett defendants.
right. All right,
Okay.
Mr. Brockett, you've got 10.
Thank you. Thank you, Your Honor. I would like to start out by addressing the question Judge Atkinson asked earlier about the allegations of conspiracy to commit civil theft, which was, you heard, vociferously denied by Don Tilsett in his argument. Record page 1027, which is appendix 60, appendix page 60. Mr. and Mrs. Tilsett and others, quote, were engaged in an active conspiracy and agreement between and among them to carry out the embezzlement scheme undertaken by Ms. Tilsett through her control over theft and disbursement and payments of the Gondolier Associates funds. And then goes on to, and this of course incorporated the previous civil theft allegations. That was count 12 conspiracy, clearly addressing theft and embezzlement and joint and several liability. So we feel like the fact that it was not alleged is a false representation, and the rest of their argument falls with it. Now, to go to the arbitration point, I think the answer to Judge Atkinson's question, which again gets to the heart of it, when the court says a person asked for a trial in open court and it's not disproven by a transcript, that goes. That's the Applegate case. It's this court's Johnson versus Deutsche Bank case. It's the appellant's burden to prove that the trial court is wrong. There's a presumption of correctness and regularity. And clearly, there's been nothing to rebut the statement that the trial court made that, quote, on the proverbial record, the plaintiff asked for a trial in open court. It's even more than that. He says, not only that, but there's two hearings. The February 26th hearing, which is page 1478, after the discussion about where the plaintiff says, I want to go to trial, Mr. Tilsett's attorney, Mr. Coleman, says, well, give us a lot of notice because he lives in Virginia. So there's no prejudice. He knew that there was a request for trial and he went along with it without objection. Moreover, page 1479, on the last day, this is the classic gotcha of all time, the 25th day, the day when it was a deadline for asking for a trial, there was a pre-trial conference in open court. The minutes of it are record page 1479. And what it says is, counsel submitted a pre-trial order this day in open court. And it's also checked case to remain on the trial docket with no objection to trial. This is the classic gotcha because the next day, the two defendants filed their motion to compel arbitration. So not only does this court say everything is in favor of trial, as the court says in Bacon Partners, trials are preferred and constitutionally guaranteed means of resolving, and a plaintiff has an absolute right to get a trial on request. And so there's an asymmetry here. There's a bias toward trial. Secondly, the rule of law is all you have to do is substantially comply. And clearly rejecting the arbitration means there has to be a trial. Because that's, and then in open court, and you have the gotcha. And again, I don't know if I'm beating a dead horse. This court has held in Kalman that even if there's judgment entered on an arbitration, it can be vacated for mistake or inadvertence in not filing the motion for trial. So again, what the trial court did was correct, followed one law, the one case at the time, Steinberg, correctly anticipated this case's result in Acosta. And as Judge Atkinson's dissent said, if you ask in court, that's okay. And I think this is a case that was being very carefully managed by the trial court. And it's not error for the court to be on top of this case, have these counsel there twice during the 20-day period, and confirm that the case was going to trial with no objection by anyone. So this is the classic case that was correctly handled by the trial court. Aside from the treble damage issue, which we asked that the court direct, and but it's not a trial issue, that's not a jury instruction issue. The application of joint and several liability and treble damages are post-trial issues. And so we would ask that the judgment be affirmed with the exception of requiring remand to impose treble damages against Mr. Tilseth individually and as trustee. Unless there are any other questions, that would conclude my argument. Thank you.
Okay, thank you both very much. I guess you're going to stick around for the next version of this case, so we'll
I will step out. Thank you.
okay, thank you, Mr. Coleman.